hocism in the matter. And therefore, we have to then draw a line. And could it be the line which was there originally, that this type of litigation is really meant as social action litigation, reserved for those who cannot approach the court in their social sufferings, in their disadvantaged people, rather than the litigation which is meant to control political power, administrative supervision, which seems to be today dominating. But at the end of it, it is largely welcome. Today, the judiciary has far more credibility than the other two branches of the government, and at least to the foreign observer, it seems to be an innovation which is worth imitating. I would like to conclude this portion and say that look what Lord Justice Wolf said on the last occasion at the Commonwealth Law Conference in Melbourne. Speaking of the Indian judiciary's role in this matter, he said, initially, I was astounded by the proactive approach of the Indian Supreme Court. But I soon realized that if that court was to perform its essential role in Indian society, it had no option but to adopt the course it did. And I congratulate it for the courage it has shown. Thank you.
The Indian experience, as narrated by Mr. Andhyavijana, bears testimony to the fact that even within the existing framework of the constitutional laws, it is the judicial innovation which can go a long way in accelerating access to justice. Mr. Justice Gopal Sriram from Malaysia, while introducing Mr. Andhyavijana, I told that he had his education, then he became a teacher, then a professor. But Mr. Justice Gopal Sriram, I find that he has been first a teacher and then a student. He had his early education in Malaysia, he worked briefly as a teacher, and then he read law at the Inns of Court School of Law. In Malaysian legal history, he is the first member of the bar to have been elevated directly to the Court of Appeal in September 1994. He is now the senior most member of the Court of Appeal, and he is an honorary bachelor of Lincoln's Inn. With these few words, I present to you Mr. Justice Gopal Sriram.
Chief Justice Lahoti, my fellow panel speakers, my brother and sister judges of the Commonwealth, distinguished guests, ladies and gentlemen. Let me say at once that it's an honor and privilege for me to be able to speak at a session chaired by you, Chief Justice. Our personal friendship apart, that is the fact that you are the head of the Supreme Court that has, as illustrated by my good friend Tempton Andhyavijana, that has done by far the most in the Commonwealth for the advancement and protection of human rights. You have taken your municipal public law out of the mire of antiquated Anglo-Saxon jurisprudence by adopting the path of judicial activism. It may be said without fear of contradiction that the jurisprudence emanating from your court has inspired many judges across the globe. One such now stands before you. I notice many familiar faces in the audience, and this is going to really put a damper on my presentation, as I will be unable to draw upon my usual existing repertoire of jokes. I have to think up new ones on my feet. Oh dear, oh dear. Now, it is my view that access to justice is the linchpin to any human rights argument. Without unhindered and unimpeded access to justice, a litigant will be unable to enforce his rights in a meaningful way rendering them absolutely useless except for pure academic discussion in a conference like this. So in a country with a written constitution like mine, Malaysia, that declares itself the supreme law, the first step is to ensure that access to justice is a guaranteed right. That is easy enough if there is an express provision in the Constitution, like for example in the Human Rights Act, in the European Convention of Human Rights. But what if there isn't? Then the task calls upon the courts to read access to justice into the enumerated, into one or more of the rights enumerated expressly in the Constitution. What the Supreme Court of India has termed under the Chief Justiceship of the eminent Chief Justiceship of Dr. Anand as enumerated rights. So you have to read into one of these rights, the right of access to justice. Well, I used to be an optimist like Mr. Andya Gianna and Lord Justice Brooke and Mr. Napier. But then after my experience, which you no doubt have read about in the paper, I have become a pessimist. You're dealing with the task of having to put into the supreme law words which are not expressly there. How do you do it? Very simple. You look at the purpose for which the article exists. The article cannot have been intended to exist for a limited purpose. Must have been intended to exist for a wider purpose. I call it, in my own little way, the prismatic rule of construction. Just as when you pass a light through a prism, it breaks down into its constituent colors, so too when you apply the prismatic rule of construction to those parts of the Constitution that guarantee fundamental rights to the citizens of the country, you will find all those constituent elements in the various words used to describe the particular right to emerge when you pass it through, as I said, this legal prism. Now, why is it necessary to read these rights into the enumerated rights? That is because Parliament has the habit of passing laws conferring very wide powers and sometimes very draconian powers on administrative officers and on elected politicians and ministers, and then trying to immunize their action by introducing a provision that puts beyond judicial review anything they do. These, as you all know, are ouster clauses. One very obvious example was contained in a recent piece of legislation here in England, which, under pressure from the House of Lords, was withdrawn. Now, the object, therefore, of the executive is to insulate itself from curial review by using its majority in Parliament to pass these kind of laws. But the object of the judiciary is to review those decisions, those very decisions, which are made pursuant to the power conferred by Parliament, which is the representative of the people. So, how do you solve the problem? You have to have access to justice as a fundamental right. Once you do that, then the ouster clause runs foul of that fundamental right, and in the words of Article 4.1 of our Constitution, any law which is inconsistent with this Constitution shall, to the extent of the inconsistency, be void. Express declaration of the right, the power in the court to declare the written law void. Now that would cause a huge tension between the judiciary and the executive. How do you get around it? Well, in a case called Sukumar Balakrishnan, We attempted it. We did it. I don't think it's fair to us to say we attempted it. We did it. What we said was that we would read the ouster clause harmoniously with the Constitution. In other words, we will not trample upon Parliament's undoubted sovereignty to pass laws. We can't be striking down all these ouster clauses. So we said, very simple. The ouster clauses, we will allow ouster clauses to survive. In other words, they will protect, they will immunize all those decisions which are made in accordance with law. Now what does that mean, in accordance with law? Well, it doesn't mean anything at all. But what it does is that it's just a collection of words in accordance with law. But what it does is it puts in the hands of us, the judges, the power to examine decisions and to decide whether any particular act or decision was illegal. That the executive is prepared to accept. So to ease the tension, we said that was the way in which to go. And we said a number of things in that case, but one of them is that access to justice is a fundamental right. And we did it in this way. Our Article 5.1 resembles the Indian Article 21, but only in a general way. Let me tell you what it says, and then I will remind you again what Article 21 says. Article 5.1 says, no person shall be deprived of his life or personal liberty save in accordance with law. Notice the words, save in accordance with law. But law doesn't mean enacted law. If you look at the definitions in our Constitution, it includes the common law, and as you will see from my paper, common law is defined in our Interpretation of General Clauses Act of 1948, which is now incorporated in the Consolidated Acts, as being means, not includes. Common law means the common law of England. And as Lord Justice Brooke has pointed out, by the common law of England, access to justice is a fundamental right, a basic right, constitutional right, whatever it may be, except that in Witham, Justice Laws said only express words in a statute can take it away. But in a constitution, you can't have that position. Express words in a statute cannot take it away because the constitution is the supreme law. So in this way, the common law right of England, in England, has found its way into our constitutions. We thought, well, England doesn't even have a written constitution, and this is a basic and fundamental right in their country. Why can't it be in ours, which has got a written constitution? So we said, yes, access to justice is a fundamental right. And we thought we got it right. And we were resting in some comfort. But it was not to be, because the government of the state, which was affected by our decision, appealed it to the federal court. Now, distinguished guests, ladies and gentlemen, I must tell you this. The Court of Appeal in Malaysia sits in a bench of 3. On this occasion, the federal court sat in a bench of 2 and reversed us. I have described the intellectual strength of that court in my paper. Somebody said I'm inviting trouble. Perhaps I am. So that I can succeed in an action for defamation on the ground of justification. Defense of justification. Now, that court, speaking through its our former Chief Justice, said, 1. The words life and personal liberty or personal liberty, the critical words appearing in Article 8, have no extended meaning. In other words, life means you can live. Law means written law. In other words, we are now engaged ourselves in reverse gear and headed back to the 50s. AK Gopalan against the state of Madras.